Hi, I'm Donovan Dobbs with Appleby Healy Law Firm. 2021 is a new year, and lots of things are the same, lots of things have changed. As for here at Appleby Healy, one of the things that has changed is we are sort of dividing into different divisions. We have a litigation division where I am the managing attorney for that division. And litigation division would include any kind of either civil litigation, criminal cases, employer-employee related issues, personal injury, basically anything that's going to require fighting and contestation, we're going to handle that. I just kind of want to talk about some of the things that are the same as last year. Last year, obviously, COVID broke out, and the court system in the state of Missouri and in the federal system were put into chaos because of the restrictions and the effects of the pandemic. Unfortunately, even though we have gotten better with the vaccines coming, the social distancing, there still are a lot of traps that a person can fall into if you're not aware. One of the things that is going on is that in the state of Missouri, the Missouri Supreme Court has set down certain phases that a court can be on depending on if certain court personnel have been diagnosed with COVID. It's phase 0 through 3. Phase 0 is you're basically not having court at all other than under extraordinary emergency circumstances. Phase 3 is court being open to basically like it was pre-COVID, with the limitations of having to wear masks and keeping your social distancing. But other than that, court is basically operating as before. The challenges right now for people and even for the attorneys is that each court and each circuit is able to determine what phase they are on. And in certain courthouses, the judges are also able to determine what phase they want to be on. So for litigants and people that go to court, you may not know if your judge is on phase 1 or phase 3 or phase 2 because of the different phases that the Supreme Court of Missouri has put down. You may be having court by in person or virtually. You can do it by your smartphone or through your laptop. Now, the important thing you need to know is that the court will send out notices to either your attorney of record, if you have one. If you're a pro se, they're going to mail it to the last address that you have on file with the court. If you have the wrong address or you did not give them a correct address, you won't know that you have court, and you will come to the courthouse and you will not be allowed in depending on the phase. So it's also good to make sure that you keep in good contact with your attorney or the courts. Also, I think that's the challenges this year is that with the social distancing, with COVID, with testing, the employer-employee relationships are just becoming a little bit more muddled than before even. We know that the employers we represent, you have people coming off work saying, I have COVID. What do you do? I mean, we want to make sure that obviously they have a test, that you have any test that is given, you will have written documentation saying that person either tested positive or didn't test positive. As an employer, you have to look at, well, even if they tested negative, were they exposed to COVID in their home? So then you have the quarantine issues, and all these are different issues that are still going on, even though testing is progressing, but it's not progressing to the point where it's in the entire general population. So we've always, on the litigation side, we're always talking to the employers as well as the employee that when it comes to COVID and the restrictions that the federal government and the state government puts on based on either a positive or negative test or even exposure to someone that has a positive test, you want to openly communicate with each other as an employer-employee, and you also want to have documentation to support that, yes, there was a positive test. Unfortunately, as we all know, some people aren't always as straightforward and honest as they need to be regarding a test. So it's always good to have it or not have paperwork. We hear the things on the news regarding COVID and it stops this and it stops that. One thing we need to know and that we're really cognizant of in the litigation division is that the rules that are set down by the courts in cases have not changed. What I mean by that, like the statute of limitations, meaning the time that you have in which to file a claim, let's say from a car wreck or a breach of contract. COVID does not affect the time limits that are imposed there. If the judge orders you to do something within a certain amount of time, generally COVID is not going to affect the judge's order regarding when you are supposed to have something done or not done. So it's always keep in mind that if you are a pro se litigant, that you're checking with the court, that you're doing the things you're supposed to do. If you have questions and you're not represented by an attorney, you always need to seek legal advice regarding statute limitations or any other limitations that may be applicable to your cause of action, because again, simply you having COVID or somebody in your family having COVID may or may not affect that. And if it does not affect it, then you may lose the right and the possibility to pursue a claim that you rightly had. And when in doubt, if you have any questions, we're always here to assist you. Feel free to call us here at Appleby Healy at any time, and one of our attorneys will be glad to answer any questions that you may have. Thank you.